afternoon, and thanks for viewing into APN Play. We have with us today a healthcare attorney, Liz Callihan, formerly with Henry Ford Health System, now in private practice. Liz, thank you for joining us today.
Thank you, Anjali. It's a pleasure to be here.
It's good to have you. Why don't we start off with a little bit of background?
Sure. I have been practicing healthcare law for over 25 years. I've been in-house counsel, and I've also been in private practice. And most of my clients are healthcare organizations, including healthcare systems, hospitals, physician groups, universities, ACOs, and health plans.
Okay, let's start with Henry Ford Health Systems. How long did you work there for?
I was Deputy General Counsel for almost 5 years.
And what kind of, for our viewers, let's kind of break it down. What kind of work did you do there? What was on your desk on any given basis?
Yeah, sure. At Henry Ford Health, I oversaw a team of 12 attorneys, and we were broken into 4 practice groups. So we handled all of the legal work for the entire health system, ranging from all the regulatory work, investigations. We handled the real estate work, mergers and acquisitions, employment matters, litigation. Any type of legal work that came through the system was our job to handle.
And you were there for 5 years, and now you practice privately.
Yes, and I have previously been in-house counsel at Health Alliance Plan early in my career, and then I was in private practice for a long time. And so altogether practicing healthcare for about 26 years.
Now, as you know, I practice healthcare fraud, and you practice healthcare law. So give me an example of a type of case you know that you might be handling this week.
Okay, sure. A case could be physicians want to invest in an ambulatory surgery center, for example. Another good example would be...
Who would you be representing in that?
The physicians.
Okay.
But I could also, in another matter, be representing the ambulatory surgery center. So it's a corporate transaction between 2 healthcare providers. They want to do it like a joint venture or invest in each other's clinics or surgery centers, for this example.
Okay.
So I could represent either side of the transaction. And in this case, it would be the physicians.
Okay.
And another case would be a potential data breach that a healthcare provider experienced. Was a physician's assistant posted information on YouTube about a case and helping determine if that was a data breach or not, was HIPAA violated or not, and if yes, what would the next steps be to correct that?
Data breaches, it seems like we're reading every day about data breaches, so you must that must be a really an area that's ripe with litigation right now.
It is, and really it's one of my niches within the healthcare practice, yours being fraud,
right.
Mine being regulatory, but in particular privacy and security cases. It's probably done more work in that space than probably any other space within healthcare.
Every time I sign up on these patient portals, I have to wonder where my information is going to.
Yes.
So do you have experience with data breaches as they relate to these patient portals? Because I know all the hospitals want us to get on these patient portals. Nobody wants to talk to us on the phone anymore. Nobody wants to, deal with you face to face. They just want you to go on the portal.
Yes, I have a lot of experience, both as a healthcare attorney and as a patient like you, using patient portals. I have to say I'm personally a huge fan. Huge fan of patient portals. And so I don't dissuade anybody from using them from a privacy and security standpoint. We had breaches when medical records were paper. And we're going to have data breaches when our medical records are electronic. So it's more the nature of the information, less than what format that information is. So any cons, certainly there is some exposure, there is risk, there's a lot of responsibilities healthcare providers have for maintaining patient portals and EMRs. But the upsides, from my experience, from my perspective, far outweigh the risks.
Eventually it is more convenient for the patient as well.
Yes.
Do you work at all or interface with insurance companies? Blue Cross and the like?
Handling if there's a payment dispute, for example, between a payer and a provider over a claims denial, for example, or if a third-party payer wants to do an audit of a provider,
Okay.
of their billing, and I'll handle those types of cases.
You have a real breadth of experience in healthcare law.
Yeah.
I'm limited in my little box of healthcare fraud.
That's a very important box. Very
Well,
important
yes,
box.
different from you though.
Yeah.
We were talking before you came on about the Supreme Court decision, which I call it Chevron, even though Chevron was overruled. Am I correct?
You are correct.
Okay, let me have you kind of walk my audience through what has happened in the Supreme Court last week as it pertains to this case.
Sure. The Chevron doctrine, or the Chevron deference, it's also referred to as, was, as you said, essentially overturned by the Supreme Court decision that came out last week, in the case is called Loper.
Okay.
So in effect, Loper kind of overturned the Chevron doctrine, and that was the doctrine that we'd been operating in for about 40 years. Chevron was a Supreme Court case, and that, in short, said that if a statute is ambiguous, or if there's kind of gaps in this statute and how to interpret it, the courts are to rely on the federal agency's interpretation of that statute. So it was deference really from the courts to the executive branch, under which all the federal agencies kind of fall under.
Okay.
And that's been the framework that we've been under, and certainly all of my work on being, a heavily regulatory focused attorney, dealing with the federal agencies and the enforcement agencies for my whole career, and really having to work with and interpret and understand and apply and advise on a huge amount of regulatory body, that all the regulations, policy statements, bulletins, interpretive guidelines, the entire body of work is enormous that has been generated by the federal agencies. And with healthcare, as we both know in our fields, is such a highly regulated agency or industry, we look to the regulations every day in terms of how to advise our clients. So going back to, that's the background, and with the Loper case, the Supreme Court said, no, in fact, it's really the court's authority and responsibility and role to interpret the statutes as they see it, and not defer all that authority to the federal agencies. So that's the big takeaway. So it really puts in play all the future rulemaking and the future weight of the regulatory work that the agencies publish. It doesn't change anything looking back,
okay,
but it changes everything going forward. And it's such a new decision just last week. Certainly not just the legal industry, really all industries, including healthcare, I think in particular, is really digesting, what does that mean?
Right.
I think it can mean certainly more challenges for when an individual or an organization wants to challenge regulations or policy making. They will be much more inclined to go ahead and make that challenge because they know that they've got a better shot at making their case to the courts now that Chevron's been overturned,
right,
than before, because the courts are really free to take a really fresh look at these arguments and look at the statute. The courts will certainly, and I think they still should be looking heavily to the agencies' rulemaking and regulations, and giving deference to that as because they're truly still considered, from my perspective, subject matter experts.
Right.
And so I don't think that all the regulations and the policies, bulletins and things like that are going to go away or be meaningless. They're going to have less import, less weight.
Can you give us an example of an ambiguous regulation? Because this is very ambiguous right now.
I'd like to make a segue too, because it's the same kind of topic. We were just talking about patient portals a minute ago.
Yes.
There was another case, not a U.S. Supreme Court case, but a case out of a federal court in Texas about the privacy and security relating to trackers, web trackers. And
what's a web tracker?
Taking a step back, if you're a user and you go on a website, the owner of that website can track where you're going using your IP address, track how you're using their website.
Okay.
And it's really kind of a fundamental part of having a website, knowing how it's operating, how people are using it. But when you're a healthcare organization and you've got a website and you have users, users going onto that website using an IP address, either they're logging in because they also have an account or log on with the healthcare organization, or they don't. So it's either authenticated when you log in or unauthenticated when you don't.
Okay.
And you've got your IP address, and if you are, researching how can I make a healthcare appointment, is there any just general information about cancer or brain tumors? So there's so many different ways we as the public or patients use healthcare websites. And so the Office for Civil Rights is an agency within the Department of Health and Human Services, one of the big agencies that's really the primary regulator for the healthcare industry. Mm-hmm. Well, the OCR, Office for Civil Rights, is in charge of interpreting, enforcing, regulating, less interpreting now, but enforcing HIPAA in the privacy and security rules. Well, there was some really fascinating investigative journalism that revealed that the web trackers that healthcare organizations were using, just like really any other industry, to see how well their websites were operating, what types of ads could be popped up, things like that, was going to an outside entity like Google or Meta, who's helping that organization do data analytics, analysis of how the website's working, etc. And so based on that investigative journalism, I think it was fascinating because a lot of organizations and much of the public certainly wasn't aware that information from an individual's IP address going to a healthcare organization's website, maybe to a patient portal, maybe to a member portal, maybe doing some sort of symptom survey, could that be going to a third party? And so that was really explored by not only this investigative journalism, but also the Office for Civil Rights obviously took a huge interest in this. And so they issued, and circling back to Chevron or those concepts a little bit, they issued a bulletin, sort of technical advice to their regulated entities, the healthcare providers, health plans, and said kind of the do's and don'ts. Because back when the privacy and security rules were issued, and back when the HIPAA statute was enacted by Congress, 30 years ago almost, there wasn't this concept of these web trackers at the time.
Right.
So they didn't really anticipate that and really couldn't address it in the statute or in the regulations. So the Office for Civil Rights didn't really have time to do new rulemaking on this and issue technical guidance, which they have been doing over the years, like many agencies. Well, their technical advice in their bulletin about the privacy and security of web trackers was challenged by the American Hospital Association and a couple health systems in Texas. And that court found that the OCR went too far, that they were being too restrictive, and their interpretation of HIPAA and their authority to make these interpretations was too far. So connecting that to Chevron, we're kind of seeing the same tracking where the courts are ready to challenge the agencies and how they're interpreting the law. And that just came out just a couple weeks ago. So,
and that was in Texas, was that a district court in Texas?
Yes.
But it is parallel in that it sounds like the courts are restricting the authority of the agencies.
Yes, that's right.
Interesting.
Yeah.
Which is the authority in your practice, which is basically what you folks in your practice have been relying on all these years.
Yes. And so so I'd say, lawyers in this space are really, really the whole legal profession, anybody that deals with regulations or federal agencies, it's really kind of a new age.
Yeah.
I think we can see more legal challenges. So we're going to see a lot more litigation.
Do you have? Is there a regulation that is notoriously ambiguous that we can just sink our teeth into? You probably know many, but
yeah, there's so many, and there's so many, kind of another hot topic now is like the staffing ratios for nursing homes, like number of nurses per patient, and that type of rulemaking that's not in the statute, that the agencies are saying we don't have it in the statute, or we think it would be part of this statute and we have the authority to issue rules on this. I think that those are the things that are going to be up for challenge.
I see.
And so you've got statutes that are really pretty short. Let's just say a couple pages, and then the federal agencies issue hundreds of pages of regulations. And so I would say I would have a harder time pinpointing a statute that's not ambiguous. That would be a much shorter list.
So the federal agencies are obviously very unhappy about the decision.
I would think so.
Because the Supreme Court has really just cut off its legs and said, no, it's on the courts.
It's on the courts. And so I think how much of their legs are going to be caught off is still to be seen. I think there's going to be some chilling effect on rulemaking, because I think there's this clear sense that it's not going to carry the weight that it did have, and that it's really going to be subject to challenge too. So I think there's going to be some chilling effect on rulemaking. And they also know it's going to be, challenged in courts. I also think, and my concern, I think it's going to be tough for my clientele, and this is true really across all industries, in the organization that's regulated. We're going to have different court decisions interpreting statutes differently.
All over the country,
over the country.
Right.
And at least when we had the federal agencies, it was the federal agency for all.
Yeah.
And so I think that's going to be a challenge, especially for organizations that are national. And so I think that's going to be an uphill battle. So
it actually sounds like it's going to be a mess.
Yeah, I think it's. Yeah, and some say on the other side of this is the overregulation on industry. Maybe it was going too far. Maybe it needed to be scaled back. But this is a big scale back.
It's a
Yeah. So it'll still have weight, certainly the regulations, but not the weight it had.
Not the deference.
Not the deference.
So, okay.
We also may see, and this will take, I think, a few more years, Congress enacting statutes that really give more clear authority to the agencies of what more clear, I guess, delegation of interpretation.
Yeah.
I anticipate that may be kind of a correction of this Loper decision, but I don't know. It's to be seen.
I want to segue into artificial intelligence because I know in your practice it's a hot topic. Yeah. But what I wanted to ask is, has that been regulated at all, or is this because it seems
no,
not because it's too fresh.
It's so fresh, and there's a lot of different initiatives to regulate AI, but not in the legal space. Certainly, no. I think we're going to see some guidance and resources from like state bar associations on the use of AI. So that's really where I see it happening for at least the practice of law.
Can you tell us how AI is affecting healthcare law? Because I know it's right there at the forefront.
Yeah, it really is, and really any, not just healthcare law, but any practice of law. Just from the simple things of using it as a tool to draft contracts, to analyze contracts, to prepare a research memo, to write a brief or a motion in court, to analyze a huge number of documents as part of discovery. And so I think it's a phenomenal tool to use. But I think it was met with a huge amount of skepticism. I think healthy skepticism, very healthy skepticism. And now I think attorneys and really the general public are becoming more comfortable with using it. But there are some risks, huge risks to it, a huge upside, but with a huge upside comes huge risk, and if you can manage them both, I think it's going to really benefit the practicing attorneys, but really it's quality control.
Yeah.
And picking the right tools, AI tools that are designed for legal work. So vetting the tools that you're going to use, and really looking at what your quality control is. You just cannot accept what it generates. We've heard these cases where briefs are being submitted to
I
courts,
know.
and the cases that these lawyers are citing don't even exist.
I know.
And they didn't double check it.
Then that's on us. I mean,
yes.
honestly, how foolish are we if we're not going to double check what the computer has generated?
It's so true.
Yeah.
And so I think with adding human intelligence to artificial intelligence, we'll get us the best of both worlds. But it's all very cutting edge, and people use it in all different ways.
I think, I know, because I have a family member who works at Henry Ford, that Henry Ford was really at the forefront of using AI. Was AI already in place when you started, or did that kind of explode while you were
really,
there?
AI has been around for years and years. And it's just the generative AI, taking it to the next level, the Chat GPT.
Yeah.
And it being able to push out, just bodies of work is the game-changing piece of this. And then in Henry Ford Health, like other healthcare organizations and other organizations all throughout the country, really should have a policy of how do we use AI here? How do we vet it? How are we making sure that we're using it really effectively and harnessing its power and mitigating the huge risk that comes with it? And so really all organizations should have a committee and a policy and a work group who's really doing a deep dive. The technologists, lawyers, compliance, the users, the stakeholders who want to use these tools, all be involved in this. So it's not just the wild, wild west out there.
Which is what it seems like right now.
Yeah.
Liz, what was your takeaway from working for the Henry Ford Health System in terms of patient care in this country, and where are we doing well as a country, and where are we failing our patients?
Sure. My perspective, at Henry Ford Health certainly, and with my other clients, is the lack of inpatient mental health care. I think that is where patients are being dramatically and devastatingly underserved. And so we've seen, patients, and this is really true across the state and in other parts of the country as well, patients sitting in EDs because there is no good discharge plan for these patients.
ED is what?
Emergency department, the ER, or in inpatient beds, because there's not enough beds in a proper care setting for these individuals. And so that, I think, discharge planning for mental health patients, pediatrics in particular, adults as well, really, I think it's a healthcare crisis in our state and in the country.
Mental health care has finally become okay to talk about and okay to admit that you need. So it's a little bit ironic and somewhat sad that the hospitals haven't caught up with that.
And that's a great point. Now that we have societies willing to raise their hand and say, I need this, but then not having the resources to do it. And so, it's a complex problem, and it's going to be a complex solution. And so I give kudos to all the healthcare providers that are doing the best they can in the healthcare field and the behavioral healthcare field. But just the lack of, I'd say the lack of beds and the lack of professionals. It's a shortage.
In terms of an inpatient scenario.
Both. But I would say most acutely inpatient, but even outpatient, there's a shortage of resources from what I've seen.
So the way
demand is higher than the supply.
So what that means is, I think people are coming to the hospital for a variety of reasons, but they identify mental health care as something that is necessary, and we really don't have anywhere to send these patients.
And in the places that we do have, they're at capacity. They're at capacity, and so if somebody's having a mental health crisis or severe mental health illness, and they wind up in the ED or in the hospital setting, the inpatient psychiatric beds, they're full. So it's supply and demand. It's a mismatch.
Wasn't there a major mental health center that just opened up in Detroit? Do you know what I'm talking? I don't know that the name escapes me, but I was listening to the mayor talk about it.
Yep, I'm not familiar with that one in particular,
Okay,
but there's been some great developments, people trying to address these solutions.
Yes.
In a mental health care behavioral health hospital opening up in West Bloomfield.
Oh, okay.
Henry Ford Health joint venture. So that's fantastic news.
Yeah.
More resources in Detroit. Although I'm not personally familiar with.
There's some, I don't know what it is, but I know there was a mental health. I heard the mayor talking about, or maybe I saw the opening ceremony of some gigantic mental health care facility.
It's fantastic.
For underserved neighborhoods in Detroit. So very fantastic. And I think the public schools are, I mean, I don't think they're there yet, but they're shifting toward providing mental health services for our kids in the public school system.
Those.
Yes.
Yeah, and the school-based health clinics are fantastic.
Yes.
So that's another great way to meet the need.
Yeah.
Mm-hmm.
Yeah. Well, we're so happy to have you this morning. Time went by so quickly.
It sure did.
I'm really happy to be educated on this Chevron decision because a lot of cases came out of the Supreme Court last week, and that was one that I didn't have time to. Yes. And I don't know. I guess closing remarks. Let me ask you if you had to identify one change in healthcare, in the practice of healthcare, that you'd like to see over the next 5 to 10 years. What would you say?
Let's see. I think some resolution to the rulemaking authority of federal agencies after the Chevron case. I think that's going to be helpful. I think wherever there isn't a bright line rule, resources are spent on struggling with those issues, just sort of kind of from the legal perspective. Certainly the mental health care crisis, and then in controlling costs. Those are just the major ones.
Oh, I didn't even ask you about what about prescriptions?
That's an interesting topic. I mean, thinking of prescriptions, one really interesting difficult phenomenon that has been a trend over the last few years that I only really became familiar with was drug shortages for cancer patients. If there's a manufacturing hiccup and they can't produce, the drug manufacturers can't produce the drugs to treat cancer, then health systems are flipping to how do we ethically allocate scarce resources? Which patients get those drugs? And it's an interesting phenomenon because it was like when we were in the pandemic, a shortage of PPE, a shortage of ventilators, a shortage of the vaccine early on, and who gets them? And then how do we make those decisions? And I'm fascinated by the biomedical ethics questions. It's the reason I got into healthcare law. And then being able to work on with the clinical leadership, with the ethics teams, with the lawyers on my team on how to draft these policies and how do you prioritize in an ethical way when there's shortages, let alone the cost of it.
That's a scary thought.
Yeah. So that's also another, I think, something that's a little bit under the radar. It certainly wasn't on my radar until I was faced with being part of a problem solver.
Yeah. Well, I'm grateful for your work. I know what you're doing in the healthcare field affects all of us, anybody who needs healthcare, and I'm grateful for your work. And it's another aspect of the law that people don't really think about. They think about lawyers and traditional lawyers, and you and me have more untraditional subject matters. And thank you for coming on this morning.
Thank you so much. And it's an honor to be able to represent my clients and defend the front line and support them. It gives me a lot of job satisfaction, and thank you for giving me the opportunity to share my passion for that.
Yes, absolutely. Liz Callihan, I hope you come back.
Thank you,
really,
Anjali.
whenever you want. And
I would love to.
Audience, thank you for tuning in to APN Play.